Mr. Hayes, what you did here today, let's take nothing away from this. It's your fault. What you did was horrific. We are on the record today now for the 28th Circuit Court here in Wexford County, and we are going to begin today's docket call by taking up the case of People of the State of Michigan versus Michael Peter Hayes. This is case number 24-13917 FH. Appearances, please, beginning with the Assistant AG's office.
Good morning, Your Honor. Good morning, Your Honor. Erica Tusar on behalf of the people, P56831, assisting the Wexford County Prosecutor's Office.
Thank you.
I'm Jeff Harrison. I'm here on behalf of Mr. Hayes. He's joined me at the table.
Also joining us this morning via Zoom is Detective Sergeant Douglas Bauman. He is with the Michigan State Police and was the officer in charge of the case. Also present, though, this morning is Miss Lindsay Simmons. She is the agent from the Michigan Department of Corrections that has prepared today's pre-sentence investigation report. And again, we are here today for sentencing on 3 different charges. First, let's begin with the Assistant AG. Ms. Tusar, have you received a copy of this report? And if so, do you have any amendments or corrections or objections to the content of the report?
Yes, we received a copy. No objection to the content. I think there's one scoring that should be changed under the PRVs, and that would change the guideline range if the court accepts those changes.
All right, and what is that change?
I believe PRV 2 should be scored at 5 points because of the fleeing and eluding charge that Mr. Hayes has, which would change the PRV total to 27 points and the level to a D rather than a C.
All right, thank you. Mr. Harrison, on behalf of the defendant.
Well, this has been the subject of a great deal of discussion between myself and Ms. Simmons. And I should not speak for Ms. Simmons. I will not do that. I apologize. My take on it is that although that conviction occurred prior to this conviction, the act itself occurred subsequent to the acts that are being sentenced today. So we believe it predated, this offense predated that conviction or that offense, and it should not be counted.
Ms. Tusar, your response, ma'am.
I'll leave it to the court's discretion.
All right, thank you. One moment.
What the detail.
All right. Well, whether or not it's scored and whether or not it's scored as a PRV2 is a different question. Is it a subsequent conviction? It occurred before this, but the events occurred after the events here, but it occurred while this case was pending. Now, another question here that I noticed is PRV7 is only scored at 10 points. I don't know why it's not scored at 20 points. Miss Simmons, do you have any response there? Because shouldn't it be 20 points for 2 or more? And he's got that felony firearm and he's got this other charge that we were just talking about.
Yeah, sure.
Yeah, so I think PRV2 should remain scored at 0, but I think PRV7 should be increased from 10 points to 20 points, which now means that the total PR, and that should be reflected on both of these SIRs, and that will increase the total PRV points from 22 to 32. And it will,
232, I'm sorry.
yep, that's all right. And let's take a look on a D grid. That is going to increase it from a C to a D PRV category. And that's going to impact the guidelines, at least thus far, by increasing it from a 29 to 38 to a 29 to 57. That's on count 3 of 3, but let's go backwards. And it's, I'm going to note this, Ms. Simmons. It was a little bit confusing to me as to the way you guys listed these. Like if you look at your SIRs, yeah, I have only 2 SIRs, which of course, because the first one is the 2 years. And then you listed the dead body mutilation as 3 of 3, which is consistent with CFJ 140. No, actually, it's not consistent. It's inconsistent with CFJ 145, where you listed it as number 2. So I think the SIR should say, or the mutilation disinterment, that should be conviction 2 of 3.
Yeah, sure.
All right, and then the next one, which is the manslaughter, should be listed 3 of 3, which is consistent with how you labeled them on CFJ 145, page 1.
Yeah, sure.
Okay, all right, good. Now let's go back. We've already corrected the scoring as stuff, and I'm going to come back to you just a moment, Mr. Sorry, don't think I forgot about you. So then we look at the manslaughter charge, which is a class C. That also now is going to be increased to 32 points. That's going to increase the PRV level from a C to a D, and that is going to increase the guideline range from 43 to 86 to 50 to 100.
Yep.
All right. Now, Ms.
Your Honor,
Chief,
for clarification, you said 50?
50,
Thank you.
50 to 100.
Thank you.
All right, thank you. All right, Ms. Tussar, we were still with you. Do you have any other amendments, corrections, or objections to the content of the pre-sentence investigation report?
No, Your Honor.
Mr. Harrison, how about you, sir?
I have no proposed corrections or anything to the body of the report.
All right, I'm going to take just a quick look here to check my notes to make sure whether or not I did or did not have any. Thank you. All right, next, we know that I have a note here that there's a victim impact statement. So before I turn to the defense for allocution, I'm going to turn now to the people and the victim advocate, Ms. Frick, who is here. Ms. Frick is escorting a speaker to this podium. All right. And please state for me your first and your last name.
Serena Garner,
And would you please spell them for me so make sure Nancy gets it correct?
Serina Garner.
Yes, ma'am. And your relationship to the victim?
I'm my dad's, that's my dad.
Your father? All right. Sorry for your loss. Thank you, ma'am. Anything you wish to say?
I have something I'd like to read.
All right. Nancy, your voice right now at the bottom is fine for me. Nancy, I know the air conditioning's on. Are you still able to pick it up?
Good.
All right, good. Thank you. Yes, ma'am. That's okay. Maybe right now we're here for you. Take your time.
My name is Serena. My dad's firstborn. He called me Buki. He said from the first time that he held me, I was and will always be his Buki baby. I wanted to tell you just a little bit about my dad. He was a free-spirited person who loved us girls and his grandbabies and his mom more than anything. He was so proud of us all. He had a very caring heart, and he had a soft spot for helping people, mainly to help people get sober, because my little sister passed away in 2020 from an accidental overdose. One of his ways of grieving and finding positive in the negative was to help people get sober, and he did help many. He loved music. He would crank up the tunes, as he would say, and sing at the top of his lungs and dance around. I remember when I was a very little, maybe 4 or 5, we cranked up his stereo and we were listening to AC/DC Dirty Deeds.
I was gonna interrupt you and ask you what was his favorite song to dance to.
He didn't have a favorite one. He liked very many songs.
All right, but you at least said AC/DC. All right, we're good.
That
Keep
was
going.
a connection with me and my dad, AC/DC, yeah.
Thank you.
We were headbanging and dancing. The joy and connection with my daddy was one of the first of many memories I can remember. I will forever keep it in my heart. I will never forget his infectious smile and his goofy, one-of-a-kind laugh. You could be having one of the worst kind of days, and you could be so angry, and all he had to do was laugh, and your whole mood would shift to happy. My dad could always lighten the room. Also, one of the things I will miss the most. Taught me many important things in this life, like how to properly shake hands, be polite, and always help others. Always be kind, even when you're standing around. My dad always had good advice. I usually didn't take it, and I had to learn the hard way, but he was usually right. I remember the day that I got saved. I asked Jesus into my heart. Everyone told my 12-year-old self that I was crazy and that God wasn't real. I called my dad, and he was so excited and overwhelmed with joy for me. He taught me so many things about God and the Bible. I will forever be grateful for that too. When I was 15 or 16, my dad went to Florida to help with Hurricane Katrina, rebuild and relief. Almost a year of him being down there, and I moved down with him. I was singing in my room when his friend asked me to sing in their reggae band. My dad loved my voice and wanted others to hear it too, and he always encouraged me to sing. That was some advice I'm glad I took. While down in Florida, Dad also taught me how to scuba dive. Another one of the coolest things I've done. We wouldn't have a conversation without saying, dive, dive, dive. Which is what they say when it's time to get in the water. I could go on and on about many things that he taught me, but we would be here for many hours. I just wanted to share a few of my favorites. Past year and few months have been one of the hardest in my life. Never would have thought I would have had to hear your dad was murdered. The week before hearing those words, I had a gut feeling something was terribly wrong. Things weren't making sense. He's just going through something, or he'll call someone soon, I thought, but he never did. Instead, a sheriff knocked on my door and told me they found my dad's body on his property. His sanctuary, his happy place. I remember being numb and asking if they were sure it was my daddy. The officer replied, yes, dental records say it was him. I didn't even put together that he wasn't recognizable and he had been burned. I found that out later. From that moment forward, I struggle every day with never seeing my dad smile, hearing his voice. No more, excuse me, no more advice, no more talks, no more hugs or jam sessions. He was taken from me and his grandbabies. I've also never needed medication in my entire life. And now I take anxiety and depression medicine and sleeping medicine because when I close my eyes, all I can see is my dad burning in a shallow grave, or him on his knees, pleading for his life or calling out to God in his last moments. Was he scared? Was he ready? I'll never know. Excuse me.
All right, ma'am. Take your time.
My oldest son asked to join counseling like I do to help with his papa being murdered and watching his mom be in so much pain and hurt and anger with all of this, and on top of being a teenage boy. My dad wasn't able to be here with me to take care of my grandma, his mom, who passed away just 2 months after my dad. I always thought I would have him and my sister to be there to help me with that, but they weren't. I also thought I would be able to be with my dad passing at home, like I was blessed to be able to take care of my grandma until she took her last breath. At home, where she loved to be, and so did he. I guess some things happen how they do for a reason. And when it's my turn to leave this earth and be with God and my loved ones, I can finally have that answer. Until then, I have to keep their memory alive and live the best I can for my babies through the hurt and find joy in things and people still here with me. Mr. Hayes, I have so many questions for you. Maybe someday will be answered, maybe not. I wanted to let you know I haven't been able to fully forgive you, and I don't know if I will. Some days I feel like I have and others I don't. But what's more important than me forgiving you is God's forgiveness. He will without a doubt forgive you with grace and mercy. You just have to ask him and repent and mean it, because he knows your heart better than anyone. I know my dad was battling and struggling with many things the past couple years of his life, but now he's no longer in pain. No more struggles. There's no scars or tears in heaven. Only peace, love, joy, and happiness. I believe he's watching over me and all he loved here on this earth. I can see him smiling while he's hugging my sister and my grandma, my great grandma, singing, "Every little thing gonna be all right." Your Honor, I would like to respectfully ask that you give the man who brutally took my dad's life the max amount of time, if prison possible. Thank you.
Thank you, ma'am. I just wish to confirm, Ms. Brick, were there any other victim impact statements from any, like, all right, thank you. All right. By the way, Mr. Gardner, the song is Three Little Birds.
Yes.
All right, just want to make sure. All right, just want to make sure you knew. Thank you. Mr. Harrison, allocution, sir.
Tough act to follow. I think it speaks well of her relationship with her father, that she was able to be so eloquent here today, and despite the excruciating, painful nature of the conversation she had, I think it expresses a great deal of a commodity that's in short supply in a lot of people's lives. That's hope. And that's something that you can't account for in a tragedy, in the situations like this, that the ripple effect, how it impacts the lives of obviously Mr. Haig, who was deceased, Mr. Hayes, who stands before you today, and their respective families, but you could see how it actually impacts other generations of people far removed from the actual location of the events in question. I'd like to be able to say that it isn't a tragedy that we're discussing here today, but even in the classical sense of the word, there's no other way to describe this. I'm also aware that we've had certain discussions about scoring and guidelines, and that kind of left two impressions with me. First of all, I guess from a practical standpoint, it's somewhat moot, because if the court will recall, there is a sort of briefly stated sentence agreement pertaining to this matter that I think makes a lot of sense logically, and that it also represents the maximum of the 2/3 rule, if you will, with regard to the sentence that the court will impose here today. The other thing of it is that it often strikes me that there are things that aren't quantifiable. The guidelines deal with, for the most part, things that are quantifiable, right? The prior number of felony charges one has, the contemporaneous felonious acts, the concurrent felony charges for which one has pled guilty or been convicted. Those are all things that we can count. We come up with a number and we assign a point value for that. The non-quantifiable things are impossible to quantify, hence the name, the description thereof. And that is the emotional factor, the human element of this thing, the tragic impact that it has on the people involved. And fortunately or unfortunately, in whether it's apparent or not, that also, I would also count Mr. Hayes in that number. He's obviously had ample opportunity to reflect on the events of the day in question, the subsequent events with the involvement with the police and his incarceration in the jail for an extended period of time during the pendency of this matter. I'm encouraged by a couple of things. I'm encouraged by the fact that he is able to intelligently discuss this with me and come to an agreement so we could resolve the case in the manner that we have, so as not to, I suppose, increase the size of the ripples here by exposing this matter to a trial and all of the ugliness that is associated with that aspect of things, if you will. I couldn't think of a better word. I didn't want to say ugliness, but that's really the guttural reaction that I had to that word made it seem like it was the appropriate way to discuss that. I understand why we're here today, and I understand, I hope, what's going to happen here today. And I want everyone to know, particularly Mr. Hayes in the court, that this has been a situation that has caused me a great deal of reflection as well it should. If there's an opportunity for some growth, some good, some learning to be applied from any situation, including one with the tragic consequences of this one, I think we're wise as human beings to recognize that and endorse it accordingly. I'm not gonna belabor the point. I'm not gonna tell the court what it ought to do here. I think the answer is apparent. I think it's an appropriate recommendation because it recognizes that sentencing agreement. I think it's well thought out, it's well reasoned. And I think the course of action that we should follow here today is clearly laid out before us. We've debated this back and forth, Mr. Hayes and myself, because I do understand the court's logic, and it is logic. In these situations where we have by necessity entered a plea of no contest, you are often critical of counsel that stand before you and tell you how sorry and remorseful their client is when their client remains silent. I'm not going to do that. If Mr. Hayes wishes to express the degree of sorrow and remorse that he's expressed to me here today, I think it's appropriate that he do so. If he is unable to do so, then it is what it is, Your Honor. Thank you.
Thank you.
Your Honor,
Yes, ma'am.
sorry to interrupt, so just for clarification of the record. PRV 7, did you say that felony firearms is the, we're counting felony firearms
Well,
and?
it could either be the felony firearm, but it could also be, it's, I mean, that really also scored it. The objection or argument made by Ms. Tusar was for the flee and the elude.
Yes. I just
Wasn't
wanted
that
to
a
clarify.
felony? So it could be either one of those.
I just from reading this, as I was listening to the victim impact statement, I just wanted to make sure, because I didn't believe felony firearms could be scored under PRV 7.
Well, then I'll use the plea to elude.
Okay, just for clarification. Thank you, Your Honor.
Thank you. All right. Before I turn to the people, Ms. Garner, did the prosecutor's office go over the pretrial agreement with you ahead of time? Okay, and I see you shaking your head, yes. All right, thank you. All right, Ms. Tusar, allocution on behalf of the people.
Yes, Your Honor. Mr. Hayes should understand that he got this deal because of the grace of the family. And I hope that he sees how much impact he made to this family in taking her father's life. But he needs to know that this came about because of the grace of the family. Thank you.
Mr. Hayes, you have the right to make a statement if you choose to do so. Is there anything you wish to say today, sir? I do respect and understand that you entered a no contest plea.
I would like to just say I'm very sorry. Everybody here in the courtroom, I know that might not help anybody, but I'm truly sorry for my actions.
All right, thank you. Well, there is one argument to say that the court need not make any statement because there was a sentencing agreement put in place as to the manslaughter charge, as well as the disinterment or mutilation charge as well. And the prosecutor's office apparently did their job. They're not required to get the agreement from a family member as to how a case should be resolved, but they do need to speak with them and take their opinions into consideration. I don't need to, nor would it be appropriate for the court to go into that communication and parse it apart. We'll take Ms. Tusar at her word. I have no reason to disagree with an officer of the court that it is the result of grace. This is a or has been resolved with a no contest plea. And as Mr. Harrison is correct, I often do take issue because I have to. When the counsel say my client expresses remorse, they can't do that because the client entered a no contest plea. So Mr. Harrison's right, because this court is right in not allowing somebody to enter a no contest plea and then have counsel speak on their behalf as to their remorse. When I look at this case, I've shook my head several times. Again, the pre-trial agreement ties my hands. Never a big fan of when somebody limits the court's discretion in any way, but they've tied my hands. I guess I could go below the agreement, but I'm not. So how have they tied my hands? The maximum punishment allowed under law is 2/3 of the maximum penalty. I have no choice. So I'm always cautious and concerned because often after when people leave the courtroom, whether it's on social media or whether it's in the newspapers or it's on comments or whatever, they'll like to complain about the court. I can only give one sentence today. There is no real discretion granted to this court today. It has to be the 2/3 rule. So, but I still need to be able to express, as required by appellate and Supreme Court decisions, the reasons for proportional and reasonableness of the sentence. Well, the defendant's prior criminal history is not extensive. I, of course, do not take into consideration any charges that were dismissed. I will note that one of his cases was dismissed because he got arrested on this case. And, but I will also note he had other cases that occurred while on bond, including this offense. The defendant had been convicted of a previous misdemeanor when places like Osceola County dropped their charges. He would have to serve that one and then serve this one consecutively. But he got a benefit there because he got one of those cases dismissed when they dismissed the delivery to a minor of marijuana, an 8-year felony. When Osceola County dismissed that case, that means he got a benefit because he doesn't have to, the two sentences don't have to run consecutive to one another. And then he gets a significant benefit in this case. Oh, by the way, he had an assault with intent to commit. Hold on. So he had another felony in Berrien County, which was resolved with a 3-day jail, so that I can't run that consecutive. Let's take a look here what this case says. Court does not want anybody pointing fingers as to the sentence. The description of the offense, and I apologize to Ms. Garner, but are well described in CFJ 284A, page 4. I'm just going to read it. So I apologize to Ms. Garner. Quote, Hendricks recalled that while in the shower, she heard a loud noise like a boom and dogs barking. She hurried to get dressed, stating she was worried about the victim because the noise, quote unquote, was just not right. Hendricks recalled that when she left the bathroom, the defendant came inside and told her, quote, the victim was gone and he had to go back outside. The defendant then exited the house with Hendricks gathering her things and going outside to the defendant's truck. Once outside, Hendricks saw blood around the victim's head and the defendant pulling the victim by his feet down the hill. Hendricks stated that she knew the victim was dead. Hendricks also saw a blood trail as the defendant moved the victim's body down the hill. Hendricks saw the defendant digging a hole and the victim's body was covered with a tarp nearby where the defendant was digging. She saw the defendant put the victim's body in the hole and cover with items that would burn. Hendricks stated that the defendant took a gas can from the victim's property and they went to a gas station to get gas so the defendant could use the gas to burn the victim's body. Once they returned home, the defendant poured gas into the hole with the victim's body inside. The defendant cut down a tree and continued to try to burn the victim's body. That case somehow has resulted in what was a potential of life as a first-degree case, and even as a second degree, it has been brought down by nearly a third of what the sentences would have been. I don't know if all that was explained to Ms. Garner. I see them shaking their heads no, which gives me concern, and that's why I asked you that question. Because the prosecutor's office needs to have gone over that with you. You don't have to get your agreement. They need to have gone over that with you. If they didn't, you can take it up with the prosecutor's office. It's not my job to do that, but now the case is mine. And Ms. Garner, I didn't read that out loud for you to hurt you. I read it out loud to put this case into context. Because lots of people watch, whether it's streaming or watch the news or listen to things on Facebook and all those other garbage media, social media sources, and they love to express opinions. I just described that so you could hear it, and then I could tell you if that, all that, and the pretrial agreement and the pleas and the sentencings and the possibilities and the evidence was not described to you, you need to take that up with somebody else. It's not that I'm saying don't bring it up to me, because I'm concerned. That's why I brought it up to you. The Victim Rights Act requires that that information or that type of information be shared with the victims before an agreement is entered. Whether or not that's done does not necessarily turn into a possible reason for dismissal of the case, but it's something that victims should be aware of. That's the evidence they had. They have reduced this charge. There's no way these guidelines are adequate. When I look here, I've got a 46-year-old man who has had, and I want to highlight this, he's got quite a little drug history here over the last few years using methamphetamine daily, which definitely, once again, I challenge anybody to ever come and argue with me as to whether or not drugs are victimless crimes. And I'll note here that when I looked at the defendant's criminal history, he was 46. I expected to see some kind of employment history. Well, I did see some kind. I saw that he worked for a year. 46 years of age. Worked for about a year and he quit that job, by the way. So now I wonder, what has this defendant been doing? What has he been contributing? I also don't have one positive statement being presented on behalf of the defendant, which is okay. Again, I'm just going in here because I'm going to cover this to make sure that it is not, at least hopefully, not appealable as to the sentence. Again, my hands are tied. The guidelines are woefully inadequate. The pretrial agreement is extremely beneficial to the defendant. The fact that other counties dismissed charges and took away the consecutive sentencing that could have been done, extremely beneficial to the defendant. A person's life was taken and the people have decided it's worth 10 years. Okay? Not the judge, although that's the sentence I'm going to give, and I'm going to find that it's reasonably proportionate. The agreement, the people have decided it's worth 10 years. I'm very sorry for that. To anybody. The court gives the following sentence. The court assesses $368 state minimum fees, one $130 crime victims' right fund fee, a $300 court cost, a $500 attorney fee. One moment. $5,663 as restitution payable to the state of Michigan. And I'm going to state this, what was the restitution for again, Miss Simmons? That's for the manslaughter charge.
Yes.
As to the count for the disinterment and mutilation, the court is going to also assess a $3,000 fine.
Apologies, Your Honor. Can you repeat the 3,000 goes to?
The disinterments and mutilation count.
Thank you.
By the way, all fines and costs are going to be made a term or condition that they must be paid before parole. The court sentences the defendant as to count one, weapons felony firearm, to the mandatory 2 years. And Miss Simmons, I think we probably need to change on the SIRs, the concurrent consecutive language we always put. It always comes out, yes, it's concurrent, when technically it's consecutive to the felony firearm.
Yes, Your Honor.
Yeah, thank you. So that is 2 years. That will run consecutive to the remaining sentences. In that case, I'm sorry, in that count, the defendant, of course, gets 399 days of credit. As to the count two for the disinterment and mutilation, one moment. This is a small point. The pretrial agreement is that the defendant's sentence would be 6, or in other words, 72 months to a maximum of 120 months. However, my calculations of the 2/3 rule would be that it would be 80 to 120 months. And technically, I'm going to violate the pretrial agreement, which is a Killebrew agreement. I'm going to make it 80 to 120 months, which would allow the defendant to withdraw his plea potentially today, but we'll see if that happens. The court awards the defendant 399 days credit. That count will run concurrent with the next count. As to the the manslaughter, the most the court can give and the most that is consistent, this is consistent with the pretrial agreement, is 120 to 180 months with 399 days of credit. Take a quick look. One moment, please. And as to manslaughter, court also adds a $2,000 fine. I find that that is reasonable. Well, hold on, reasonable and proportionate based upon the pretrial agreement. Do I think it's reasonable proportion as to the offense and the crimes actually committed? No, it's way too low. But I make the fact that he has to make all those fines and costs and penalties paid as a term or condition of probation. Court also will obviously deny any request for boot camp, not that it'll probably come back up, but we'll make a note of that. All right, have I missed anything, Miss Simmons?
No, Your Honor.
Have I missed anything, Miss Tusar, on behalf of the AG's office?
No, Your Honor, thank you.
Thank you. Mr. Harrison is going to bring to you, Mr. Hayes, 2 copies of one document. This document tells you that you have the right to appeal the plea and the conviction and sentence. Because of the pretrial agreement, any plea must be done by filing, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for a leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the copy of that document and return to the court within 42 days. Now, again, place your initials on the first copy, neither elects nor waives any rights. It merely acknowledges receipt of the other copy of the document. All right. I will note that my sentences here exceed the guideline ranges for the count for the mutilation, which was 29 to 57. I went with 80. Based upon the factors that I read earlier, I find that the guidelines are inadequate. And also as to the manslaughter, I find that the guidelines are inadequate. I also find that my sentences are reasonably proportionate and they're based, and that's largely supported by the pretrial agreements reached in the case. All right. I know there has been some somberness today, and I know that my tone, I don't always know how to use it. In fact, I pace back and forth in my chambers. What tone am I going to use when I walk out there today? Garner, to you, the friends and family of your father, I'm very sorry. There's absolutely nothing the law can do to make up for that loss. Thank you for your blessings, the grace that you give, the example that you demonstrate through your faith. I myself am a person of faith, and I understand it. I often tell people, especially during the holidays, the greatest example of love, which is what Christ's life was all about, is forgiveness. That is the most difficult challenge for love. God bless his strength. Mr. Hayes, what you did here today, let's take nothing away from this. It's your fault. What you did was horrific. We are adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.